So the Federal Food, Drug, and Cosmetic Act has a provision in it that says that states and political subdivisions cannot establish any requirement that's different from or in addition to a requirement under the Federal Food, Drug, and Cosmetic Act, which relates to the safety and effectiveness of the device. And then, as you mentioned, in a case called Regal v. Medtronic, the Supreme Court held that that provisions, that preemption provision that basically says injured patients you cannot sue under state tort law, medical device manufacturers, the Supreme Court said that applies to devices that have been approved through the pre-market approval process. So only those devices that have gone through the PMA process. So I think to the extent that the cybersecurity risks relate to safety and effectiveness of the device and relate to, and whatever state tort law says is different from whatever FDA says, patients may not be able to sue the device manufacturer. They could always, or successfully sue, you can always sue, may not be able to successfully sue the device manufacturer. And patients could still sue the hospitals or the physicians or whoever else, perhaps, depending on the particular facts. But that statutory language says that requirements have to relate to the safety and effectiveness of the device. So what that means is if you're talking about a cybersecurity risk that doesn't relate to the safety and effectiveness of the device, maybe it's about patient data, that may not apply. I mean, that issue hasn't been litigated, so who knows how courts will interpret it, but it may not apply to some kinds of cybersecurity risks that patients are actually really worried about. So if you're talking about, or if you're talking about the huge chunk of devices that don't go through the PMA process, that wouldn't apply. As for whether preemption makes sense in the cybersecurity, so let's assume we're talking about the kind of claim against the manufacturer that would be preempted. As to whether preemption makes sense in the cybersecurity setting, let's just assume for the sake of argument preemption makes sense in other settings. I'm not sure cybersecurity is so different from other kinds of device lawsuits. So, yes, you go through this process to demonstrate to FDA, you run clinical trials to show that your device is safe and effective, and FDA gives it the stamp of approval at a particular point in time. But all the time we learn new information about medical products after they've been marketed. And in fact, because of just sort of the balance we've struck that we're not going to run clinical trials for 20 years before we decide that we have enough information to approve a medical product, we don't actually have a ton of information on long-term use before products are marketed. And, science evolves, other kinds of science evolve. So, I think it's maybe an open question. I'm not sure that it's so different. I'm not sure that cybersecurity, at least with respect to safety and effectiveness, is so different from the other kinds of issues that come up with medical products after approval.